Welcome everybody to today's seminar. We are so thrilled that you're joining us. My name is Hannah. I'm a legal assistant at Gibble, Crable & Hess. Today's seminar is the topic is COVID-19 and employment law. We're going to walk through a review of the past year and then how that reflects on what we can expect going forward. We're fortunate today to be joined by attorneys Jeff Worley and Ian Brinkman. They are both from Gibble, Crable & Hess. They are also both attorneys in the Corporate Practice Group, which provides comprehensive legal services to corporations and other business entities. We're also very fortunate today to be joined by Trent Hess. He is a business insurance professional from the Bcf Group in Lancaster. He has been with Bcf since 2005 and works directly with businesses to mitigate risks. Today, we are going to kick it off with some updates just regarding COVID-19 and operating a business under, a wide umbrella of conditions. There will be also a question and answer segment between Jeff and Trent about employer liability and workers' compensation. If at any point you have a question, you are welcome to send a chat directly to myself, the host, and I will either interject if it's pertaining to the current topic. We'll bring it up and discuss it. Otherwise, we may just save it to the end when we have another little Q&A section if you have questions about anything that we've talked about today. Additionally, we are recommending that you view this seminar in gallery mode during the Q&A, so you can see the back and forth between Jeff and Trent. May just be a little bit easier for you. If you are unable to stay for the whole seminar, that's completely fine. We understand everyone has time constraints. We will be posting a recording of this seminar to our YouTube page. You can just go to YouTube, search Gibble, Crable & Hess, and it should pop up. And we should have that posted there in the next couple days. I think that's everything. And with that, I'm going to turn it over to Jeff.
Hey, everybody. Who would have thought a year ago we'd still be here talking about COVID? But here we are. It's been a year. We've been navigating this pandemic and the tragedies, the loss of life and of not being together, and in some cases being together too much. Shout out to those homeschool parents, and shout out to my wife for spending way too much time with me. We've missed graduation ceremonies and weddings and church concerts, happy hour, water cooler chats, and we've navigated just a few state and federal mandates. We've dealt with employees and customers. We've had a couple of Zoom calls. And hopefully we can do this presentation soon, again, in person, so I can actually watch you check your email while I'm talking. Looks like there's light at the end of the tunnel. Somebody told me recently, though, that sometimes means it just illuminates how long the tunnel is, but hopefully we can get there soon. Just great to have you guys with us again today. We've been trying to keep this as interesting as possible, so questions, comments, please send them over to Hannah. My liability carrier requires that I tell you this. This is for informational purposes only. This does not constitute legal advice. If you have specific questions regarding a specific situation, contact us or your legal counsel. So the first topic I want to talk about today is the American Rescue Plan Act of 2021, also known as ARPA, or also known as the $1.9 trillion rescue plan. What do employers have to consider? And let's start out with the leave provisions. So I'm going to make an assumption here that you're familiar with the FFCRA, Emergency Family Medical Leave Expansion Act, and the Emergency Paid Sick Leave Act that was part of the Families First Coronavirus Response Act. That was about a year ago. And that was one of the first pieces of legislation we saw that came through. The rescue plan has further extended that leave eligibility. And again, assuming you guys are familiar with that. If you're not, you'll need to get up to date on that, but hopefully you are, because this has been in place for about a year now. So it's expanding that leave again But the big thing to keep in mind is participation is voluntary for the employer. So you do not have to offer this leave if you do not want to. If you choose to do so, the leave is available from March 31st, 2021 through September 30th, 2021. Similar rules for the tax credits. So you're just going to process it through payroll as you would before. It's paid by the government. You pay it first. The government, reimburses you through tax credits. The leave credits reset as of March 31st. So all eligible employees are now re-eligible to take Fmla and the sick leave as well. And that's regardless of their previous use of that leave. Prior unused leave does not roll over though. The reasons for leave, for the sick leave, have expanded, and they now include the worker is getting the COVID vaccine, the worker is recovering from complications due to receiving the vaccine, and the worker is awaiting the results of the COVID-19 test or diagnosis for the coronavirus, regardless of the presence of symptoms. So that's now in addition to having to quarantine, being under a quarantine order, having COVID or experiencing symptoms. That's 2 weeks of leave, and that's paid at 100% of the employee's rate of compensation. Then you have the EFMLA, and that's the extended FMLA. And again, that's not just for employers with 50 or more employees. That can be for any employer with less than 500 employees. That had been in place for parents whose child was school or daycare was closed due to COVID. But now that EFMLA is available for all of the reasons that the sick leave is available. So if somebody has COVID, they now are able to take the EFMLA. If somebody is experiencing symptoms, needing to quarantine, that EFMLA is available to them. And that is in addition to the 2 weeks. So you can take the 2 weeks at 100%, and then you have 12 weeks at the two-thirds rate. And the employer gets reimbursed by the government. And again, this is all voluntary. So you can choose not to do it, or you can choose to do it. Keep in mind, if you choose to do it, you need to do it uniformly so that all employees have the opportunity to participate. If you choose not to do it, that's your option, your prerogative to do so. Ian, is there anything else on that topic?
I would just say that employers should keep in mind how their current leave policies might be able to be bolstered by these tax credits. So think about how your current leave and your policies might be able to be aligned with the 6 and now 9 reasons for leave. And then, the leave that you would already be providing, you could get reimbursed by the government for. So I think there's some opportunity for some matching there.
And I would also jump in. We do have a question pertaining to this before we move on to the next subject. A participant is asking, under the ARP, does the 12 weeks EFMLA reset on April 1st? Or if our typical FMLA does a 12-month look back, does that stay in place so it would not be an automatic reset to 12 weeks?
My understanding, and again, we're looking for some clarification from the DOL on some of this, but my understanding is the reset happens on April 1st, regardless of your period and how you've calculated FMLA. If you are going to offer the EFMLA, it will reset on April 1st.
And then there's one more question. There's an employer who has an employee who gets tested for COVID every other week and takes 3 to 5 days off. How many times can that employee take time off for COVID testing before it's an issue and they can approach it?
My understanding from the text of the recovery bill is that employee has 14 possible weeks to use for testing, because as the expanded sick leave provides, testing, regardless of symptoms, is a qualifying reason for the leave. So you go through the first 2 weeks, and then they qualify then for the EFMLA after that. So that's a good reason. I mean, when you think about that, that's a good reason to, you know, pause for a second and say, are we really wanting to offer this? Lots of upsides to offering it, but there are, you know, other considerations as well. The other thing that the ARPA creates is a subsidy for COBRA. And many of you probably have already heard about this. But eligible employees who are involuntarily terminated from employment between April 1st, 2021 and September 30th, 2021 may stay on their employer's health insurance plan through September 30th at no charge. And keep in mind, this is not just for federal COBRA, this is also Pennsylvania mini COBRA. So you have any employee being terminated involuntarily, qualifying for COBRA, they will receive a subsidy for that through September 30th. And again, that's going to operate similarly to how the EFMLA and the sick leave provisions provide. Employers going to pay for it out of pocket and then get it reimbursed through tax credits on the back end of that. That's 100% subsidy, and that includes your administrative costs as well. And so you're not, as an employer, not going to be paying anything. Now, difference here between, you know, the previous leave provisions, this is mandatory. Your administrator who's taking care of your COBRA for you should have probably sent you a notice already informing you of opting into this. I mean, not opting into this, but informing you of how to process this, sorry. The DOL is issuing a notice the 10th of this month. That's going to provide some clarity. And that is something that you're going to have to provide to your employees and put them on notice that, in fact, they are eligible for this COBRA subsidy as well. If an employee did not opt into COBRA, they will have the opportunity to do so as well. So somebody who may have said earlier, I didn't want COBRA, will now have the opportunity to opt in. And as I said, we're going to get that model notice coming out in a couple of days, and that's going to provide us with some more detail. And that is something you're going to need to provide to all of your employees. The employee retention credit was also something that was expanded. I'm not going to spend a lot of time talking about the employee retention credit because really in that situation, you have to have lost 20 to 30% of your gross receipts. And so if you've lost 20 to 30% of your gross receipts, you've got issues, you've got problems, and you're already dealing with those with an accountant, with an attorney. But those employee retention credits are available and are available to you. Likewise, the Paycheck Protection Program is available. If you have a need for that, you should be speaking with your accountant on that.
Jeff, I'm going to just jump in here. Sorry, we had a question regarding the COBRA. They wanted just a little bit of clarification regarding reasons for termination. Does it have to be, what if it's for poor performance, or, you know, is it just for position elimination, or are there any guidelines regarding the termination?
So with COBRA, you have you're generally qualified if your employment is terminated, regardless of voluntary or involuntary. For your involuntary termination, the only time when you're not eligible for COBRA is for gross misconduct. So if somebody's stealing from the employer, somebody maybe engages in violence in the workplace, that's going to qualify as gross misconduct, and then you will be disqualified for COBRA. And that is only at the employer's initiation. So the employer would go back and say, we're not going to offer you COBRA because you engaged in gross misconduct. The employee has the opportunity to fight that as well. If an employer opts to allow an employee to have COBRA because even though they engaged in gross misconduct, not an issue, and that's quite okay to do. But that's really the only reason. So somebody who's getting terminated for poor performance, even somebody who's getting terminated for insubordination, that's likely not going to qualify as gross misconduct. I was talking with a buddy of mine the other day who is a financial advisor, And he said, you know, you can tell there's a change in the administration because I'm going through several audits already for clients. And we are going to see enforcement of the regulations now. Went through 4 years with really no enforcement. You know, Trump basically stripped a lot of these departments of their ability to do investigations. I don't recall any DOL investigations that I was involved in during the last 4 years. We're going to start seeing this happen, I think. I did have one client earlier on get an OSHA complaint initiated by an employee. And it says, you know, basically to the employer, look, we got this complaint. You put in writing that you're following the CDC guidelines and we'll take you at your word. We're not going to come out and do an investigation. That's going to change. Ian is going to speak a little bit to OSHA right now and also to some of the state guidelines that we're seeing.
Thanks, Jeff. Hello, everybody. My name is Ian Brinkman, and I'm going to continue this federal theme, talk a little bit about OSHA here. And Jeff gave a really good segue into this topic in seeing increased enforcement efforts. So when the Biden administration moved into the White House, it sent to OSHA regulators a charge to come up with federal guidelines and requirements for how businesses mitigate COVID-19 in the workplace and prevent their employees from getting sick. OSHA regulators actually didn't take advantage of that charge and instead decided to create a national emphasis program. So rather than create standard acts that businesses must enter into to protect their employees, rather OSHA has committed internally to increase their inspection efforts and just their general focus around COVID-19 transmission at the business premises. So while we don't have federal standards across the board for all industries, what we do know is that the NEP says that there will be increased enforcement efforts. And what those increased enforcement efforts will look like is a complete retooling of how OSHA approaches COVID-19. So in 2021, OSHA in the NEP and through other press releases has said that of its inspections, 5% in this year will be related specifically to COVID-19 protocols and upholding regulations. Not only will there be 5% of those inspections, but they have 2 master lists, which describe specific industries that have had issues in the past with transmission at the business premises or have had issues with general compliance. The big broad categories in that will be familiar to everyone. We're talking about healthcare, animal processing as its broadest category. So from processing to meat packing to distribution, all in-person retail, personal services, and the construction industry. So for employers on the line right now listening, you can really expect to see things from OSHA regulators in the next year or 2. Not only is there a 5% concerted increase in inspections and targeted specifically at those industries, but ARPA, which Jeff just discussed, has a $100 million line item for OSHA enforcement measures. So not only is there a plan in place internally, not only is the money there, but just the political willpower, as Jeff was saying, is also there. So this is not just a paper change of priority here. This is something that we're going to see on the ground and is something that, you know, a lot of both attorneys in the field and regulators in the field are talking about. So this is something that both attorneys and employers are going to start seeing come up more and more frequently. So we know that OSHA didn't enact federal nationwide standards, but we know they're going to increase inspections. So what are they going to be looking for when they do increase these inspections? And if you look at your outline, that takes us right to the well-known general duty clause. And we have there what the implications of the general duty clause are to just generally keep out known hazards from the workplace, and how employers are charged with doing that is by taking reasonable steps to prevent those hazards from occurring. So we know that there's an increased enforcement. We know that it's going to be tied to the general duty clause, but because there's no blanket pronouncements of what employers have to do, what should employers look to when they're upholding their general duty clause? And you can see in your outline, I have 3 blue highlights there, and those are links for resources. And because OSHA is a federal law and federally directed agency, we should first be looking at CDC guidelines and OSHA guidelines, both for businesses in general, employers in general, and then also industry specific guidance. Because of the federal nature of those are not regulations or laws that must be followed, but actual guidance. But this will help inform what is a reasonable response in the face of COVID-19. In addition to that, I think it's going to be difficult for an employer to, in the face of an inspection by a COVID regulator, say, we've upheld OSHA guidelines, we've upheld CDC guidelines, but we have failed to follow Pennsylvania state laws, which are full in effect laws. They're not just suggestions, they're on the books. So you'll see there that we also have the Pennsylvania specific standards as well. So implementing all 3, looking at all 3 and how they can be reasonably implemented in the individual business premises is going to be very important for upholding that general duty clause. So that's what we can expect to see as an uptick in enforcement, and that they'll be looking at both state and federal guidance for whether the employer has acted reasonably in preventing the infection of employees on the business premises. So as Jeff said and Hannah said, COVID has created wide-ranging changes, both in how we interact with old laws and regulations and new laws and regulations. So just as a little closeout on the OSHA portion here, it's really important to remember that to uphold all the things that you were doing before, both without regard to COVID, and then how those current practices can be informed by COVID. So here, particularly with OSHA, OSHA has said that some people may be familiar with the personal protective equipment and bloodborne pathogen standard. That's a current and a preceding COVID-19 standard. Well, OSHA is saying that it's logical that a virus can be passed through bloodborne, that COVID is a bloodborne pathogen, so that persons or businesses or employers that are subject to that standard also should implement that with regard to COVID-19. So just thinking about how current standards can be applicable to COVID-19. We're also going to see an uptick in whistleblower protections. So those again are current laws, but as regard to COVID-19 and this additional focus with the pandemic, we know that there's going to be increased enforcement of whistleblower and retaliation efforts against employees. So, just be mindful of that as well. Jeff,
employers should also just keep in mind that, we often think of OSHA as, relating to the construction industry or maybe to hospitals. OSHA applies to all of you. It's across the board, applicable to every employer. So, something just to keep in mind here.
Yeah, thanks, Jeff. And that's true too, is that, as the pandemic rolls along here and everyone gets used to the fact that these things do apply to us, that there's not as much leeway because of the severity of the virus and the pandemic, that there's going to be even less and less leeway as we get more into these measures, and that businesses are going to be expected to know about these regulations and know how to implement them correctly. So to piggyback off of our little OSHA presentation there, I want to talk a little bit about Pennsylvania specific regulations, because again, both in the federal context and both in just the general reasonableness, preventing liability from an employer perspective, it's really important to look at the Pennsylvania specific regulations and directives to couch what is reasonable and what a business's general response should be. So here you'll see a really long list of stuff in your handout, and that's really just our best effort of combining all the old and new orders and regulations and rules and try to put them in one resource for you. So this, as best as we could put together, is what is currently required of businesses, both generally and in specific industries. For now, to not exhaust you or bore you with a full recitation of all that, I'm just going to hit some important things and some new highlights on April 4th. Some of the restrictions were rolled back further. So I'm just going to take 5 minutes here and hit some of these. Really easy to do and really easy to see that it's not been done is this COVID-19 safety procedures for business flyer. And I have a little link in the handout for you there. It's just a 8.5 by 11 sheet of paper. You sign the bottom. It just says, I know there's a pandemic. I know that Pennsylvania has set out regulations and I'm trying to implement them. It doesn't mean you're taking on any further liability, but it is a requirement that you have it up. And that's something that's really easy to accomplish, but it's also really easy to see that you haven't done it because it's supposed to be posted prominently in the entrance of your business. So it's very easy for a regulator or inspector to even walk by outside and see that it's not there. So that's an old rule, but something that is a good reminder and an easy one to just check the box on. A new rule that I think is going to be really important for employers is how vaccinations affect required quarantining if there's a close contact on the business premises. So we know the old rule was if an infected person came into the business premises, hung out with 5 of your employees for 15 minutes, and then left, and you found out that that person was infected with COVID-19, those 5 employees are considered close contacts. And the old rules required that all 5 of those employees quarantine for a certain period of time, depending on the amount of their exposure and their symptoms after exposure. Now, if those 5 employees are fully vaccinated, meaning that it's been 2 weeks since their last final vaccination, whether a 1-shot or a 2-shot vaccination regime, those employees that are fully vaccinated and are in close contact with an infected person do not need to quarantine so long as they don't exhibit symptoms. So there is a wide variety of feelings and viewpoints for what vaccinations are, who should be asking questions, how employers and employees are involved, and we'll address those later. But this is one really big area where employers might want to know if their employees are vaccinated, because it means that the disruption of the workday, if an infected person does come into the business, it doesn't need to happen as much as it used to, because persons that are vaccinated no longer need to quarantine. Now, if you're not fully vaccinated, all the close contact rules still apply. You still need to quarantine for 5, 10, or 14 days, depending on symptoms and symptom abatement. So, but this is, I think, is a really big step in a good direction for employers and employees in keeping, continuity of operations going here. The last 2, I think, are probably really well known, but just nice to talk about and nice to point out is that all businesses except for restaurants right now are able to operate at 75% capacity. So we're very, very close to being back to 100%. And then restaurants, I'm sure, are very familiar with the certification or no certification dichotomy, and that allows them to be at 75% or 50% capacity. And then for businesses, we're getting into the spring wedding season here. It's beautiful outside, as we were talking about before this presentation. So all indoor events are at 25% maximum occupancy, depending on what's on the certificate, regardless of the square footage size or anything like that. And then outdoor events are at 50% maximum occupancy. So I just wanted to highlight a couple of these Pennsylvania specific regulations. They'll help inform you for OSHA compliance. They'll help you inform just for general liability, civil liability. And you can just see also that, like Jeff was saying, that light at the end of the tunnel, we're seeing these regulations be rolled back. So that's some of that light there too. And I'm going to hand it over to Jeff and Trent now.
It is good to see that light at the end of the tunnel. I mean, it felt really good today to put on a suit. I mean, I have not worn a suit in a long time, probably since I did my last webinar. And honestly, probably when I did that one, I might have been wearing sweatpants on the bottom. But real deal, suit all the way down. Got my dress shoes on, put on socks. Feels great. Hey, so Trent Hess is with us here from Bcf Group. And Bcf Group has been a good friend to Gibble, Crable & Hess over the years. We've collaborated on some presentations in the past and wanted to bring Trent in to get his perspective from the insurer's perspective on just liability questions and concerns. Trent, do you want to take a moment and just talk a little bit about who Bcf Group is?
Sure. Yeah, thanks, Jeff and Ian, for inviting me on here, and happy to be here. So Bcf Group, if you're not familiar with us, we are an insurance broker and risk management firm. We're on the Oregon Pike here in Lancaster. And I'm specifically in the business insurance division. We also have a personal insurance and a group benefits division as well. But I work with businesses every day, many local businesses, some not quite so local, but yeah, just working with insurance programs and helping to manage risk as best as possible.
So what are some of the trends regarding businesses and COVID-19? What are you sort of seeing as trends here?
Sure. Yeah, it's interesting. Initially when all the shutdowns and the regulations started happening for, months afterwards, we got a lot of insurance related questions from our clients about COVID. So the biggest question we were getting was regarding business interruption insurance, whether that was going to apply to lost revenue from the shutdowns. We had questions about liability coverage if, customer got COVID from your place of business, workers' comp issues, about reopening. Big one for a while was about whether you would lose coverage if you opened before you were supposed to open. That all stemmed from in the insurance world, what was kind of an infamous press conference that the governor had at one point last year that raised a lot of alarm in businesses. So we had a lot of questions, but the trend I'd say is that over the last number of months, we get very few questions anymore about insurance issues. So I think it almost seems to me like businesses have kind of decided that, right or wrong, if they do the best they can and try to follow the rules, they're going to be okay. And there's maybe a little bit less focus on some of the minutia and maybe a little bit bigger picture focus about just moving forward and trying to do the best you can and keep going. So that's kind of the trend that I've been seeing is less of the focus on the minutia.
When we've seen these various relief packages rolled out, one of the big things that Congress has sort of batted around is some sort of indemnity for employers, some sort of something that would say that employers or businesses will not be liable unless there's gross negligence as to COVID spread. That hasn't happened. So what do employers have to worry about regarding COVID-19 lawsuits and just risks in general?
Yeah, that's a good question. That obviously, businesses would have loved to see that immunity is given, but it didn't happen. I guess two ways to look at it. And one is just from the employee side. So about the risk of an employer being sued by an employee. That's still a fairly low risk because of the workers' comp system in general. So workers' comp is set up as a sole remedy, meaning if an employee gets injured and they file a workers' comp claim, the workers' comp is their sole remedy for their medical bills and their lost wages. They can't file a workers' comp claim and sue their employer. And at this point, people who get COVID at work and think it's from the workplace would be filing a workers' comp claim and letting it run through that system, rather than suing the employer. So there's still, the workers' comp system is still a protection there for the employer. The risk of getting sued by, the general public, we haven't seen a lot of that. That was a huge concern early on, especially in the insurance industry. And it doesn't, from what I've seen and our clients and just in the industry in general, those claims haven't seemed to materialize. That doesn't mean they won't or that there are not some out there, but it just doesn't quite seem like that materialized, the customers suing a business for claiming they got COVID. I don't quite know why that happened, but it just doesn't seem like that's materialized like we thought it might.
And are you seeing workers' comp claims being granted, employees getting workers' comp because of catching COVID in the workplace?
Yeah, that's a great question. And that's kind of a similar thing there where early on, there was a lot of concern or alarm in the insurance industry about what this would mean on the workers' comp side. There was a fear that they were going to get overrun with COVID claims. And in non-healthcare industries, that didn't really happen. I mean, there were some, but there was not a rush like we feared might happen. I would say in the healthcare industry, there has definitely been a lot of COVID workers' comp claims. So really what's come down to be the defining factor is, is whether you can tie the COVID directly to the workplace. That's what most insurance carriers are looking at when they get a claim filed. And in healthcare, that's easier to do, and they're more apt to pay those. So there's definitely been some of those in non-healthcare fields, just retail or manufacturing setting. There's not as much of that been happening, and the insurance carriers are more apt to deny those claims if they do come in. But that's really the way to look at it, is the direct path to the workplace. Meaning, if you have an employee who gets COVID and they think it's from the workplace, but they can't point to a specific exposure that happened in the workplace, and they've also been going to the grocery store the last few weeks, there's not really a direct path to the workplace, and that's likely going to be a denied claim. What can happen is if you have an employee who tests positive, and then 3 days later, the 4 people that were working in close proximity to them also test positive, that's a pretty clear direct path to the workplace. And those 4 employees would have a pretty strong case and probably would have an accepted workers' comp claim in that case. Although the original employee who brought the COVID into the workplace would not have a strong case. And that's sort of how they've been playing out. So there's definitely been some accepted workers' comp claims in COVID, but probably not quite as much as we might have feared in the beginning.
And what should employers be thinking about is, from a workers' comp safety perspective as they're bringing employees back?
Yeah, I just say the biggest thing is, the risk in general for safety purposes, not just from COVID, but from any safety purposes when you bring employees back, is that the risk increases when you go from 0 to 60 sort of. So if you kind of think about it like exercising almost, if you decide to start exercising and you go out the first day and start sprinting, you're probably going to get injured. Or, if you're of a certain age, you might get injured when you sprint anytime, but it's a little bit the same way. So if you have an employee who hasn't been working for months, or hasn't been doing that job for a long period of time, and you bring them back, just be cognizant of that. And I would try to find ways to ease them into the position. That's the best way you're going to prevent, injuries. It's the last thing you'd want, is to bring somebody back and then get a legitimate work injury in the first couple of days. So that's what I would keep in mind as you're bringing people back.
And generally, what should businesses look out for or ask about when they're renewing liability coverage?
So this is the thing to keep in mind specifically about your liability coverage that we've been starting to see is a communicable disease exclusion. So when this goes on an insurance policy, it's a blanket exclusion for claims arising from any communicable disease, which of course includes COVID, and that's why it's being put on there. So what it means for you is if you had a customer or a patient or a client who claims that they got COVID from your workplace or your operations, and they try to sue you, your insurance policy wouldn't protect you. We're at this point, we've been starting to see this primarily in the healthcare field. These are becoming already very standard in any healthcare organizations' renewals on their liability coverage, nursing homes, physicians, home care companies, that type. We haven't seen it very much outside of healthcare, but definitely keeping our eye on it. And I suspect that it'll be coming. Maybe not, but I suspect it'll be coming, and it might become a standard exclusion on insurance policies. The tough thing about it is that right now there's not really an insurance product to provide that coverage. So if you get a communicable disease exclusion on your policy, and you can't really just go and say, well, I'll buy that coverage separately. It doesn't exist at this point in the marketplace. I think it will. That'll take a period of time for the insurance industry to develop a product for that and figure out how to price it and that sort of thing. But in the meantime, it kind of puts you in a tough spot. So I would just be aware of that in your liability renewals and keep an eye out for a communicable disease exclusion. That'd be something to talk to your broker about.
Great. That's very helpful. Trent's going to stick around till the end of the presentation. So if you have questions for him, you can feel free to jump in. Hannah, is there anything?
2 things, actually. Just a quick heads up to everybody. It looks like when the handout was converted to a PDF, the links did not get embedded. So if you're frantically clicking on your PDF and it's not working, it's not you, it's the PDF. We will get those embedded and resend out the handout this afternoon so that you have access to all of those links. and all of the information that the attorneys put in there. We do have a question about, I think maybe one of the first questions that you asked, Trent. We have a business owner that says he's been threatened here and there to be sued by customers for ADA violations because he's requiring a mask, face shields, or phone orders. Is that something he should give weight to? Should he be concerned?
I mean, I would say anytime you're threatened to be sued, you would maybe be a little concerned. As far as what your actual liability is there, I'm not sure if I could answer that. Maybe Jeffrey and I have thoughts on that. That's kind of an area of risk that, those were there, but this is a new aspect to it. So yeah, I would take this seriously. Once again, in our client base, I haven't actually seen those claims materialize, but that doesn't mean that there's not a risk there to be concerned about.
What we've seen, and this generally deals with the mask mandate. So an employer or business says, hey, you can't come into our business unless you put on a mask. And then the individual, the customer says, well, I have a disability that prevents me from wearing the mask. And under the ADA, the employer or the business is technically not allowed to ask that individual, what's the disability? And so you get into this possible gray area of, is it an ADA violation? We've also then seen, well, there's face shields. And so face shields are less of an issue for somebody with asthma or breathing issues. So, and there's also, curbside pickup and things of that nature. So it kind of depends on the nature of the business. It kind of depends on things, but yes, you should take those threats seriously. And be aware that, that the ADA does protect people as it does, somebody with an animal, seeing an eye dog by way of example, to come into a business. Likewise, somebody can say, I can't wear a mask because of a disability. So it's something to be aware of.
I would just add to that, as far as your insurance goes, it's kind of an interesting scenario, but if you're concerned about having coverage for something like that, likely the place to look for coverage for that, it's not going to be your general liability policy that's protecting you for actual bodily injury or property damage you're liable for. But if you have an employment practices liability policy, we like to include in that what we call third party coverage, which extends that coverage to claims of discrimination from third parties, meaning your customers. And that's probably where, if you did get sued for something like that, you would find your coverage in your third party employment practices liability coverage. So that would be the place to look if you're concerned whether you're covered for that.
That's a great point. I want to talk just briefly about vaccines. They're rolling out. I think it's pretty much available for anybody now. Question some employers are asking are, can I make it required? And the answer is yes, you can. Caveat to that is there are religious exemptions and disability exemptions. And so somebody who has a sincerely held religious belief against vaccines, they will be exempted. And likewise, somebody who provides a doctor's note saying that this person is not able to take the vaccine will be exempted. Otherwise, an employer can uniformly, again, that's a key component there, uniformly require all employees to get the vaccine. Yes. Up to you as an employer what you want to do there. If you do that, again, it has to be uniform. And so you might have a very good employee says, I'm not going to get the vaccine. Well, now what are you going to do? So, you can also do an incentive program, free and voluntary approach, but maybe you're giving the employees the day off after the second dose, or maybe you're giving the employees $100 gift card, or whatever the case may be to incentivize people to take the vaccine. You can also ask employees if they have been vaccinated. So back to Ian's earlier point, of why that might be a good idea. That's why, is because you would now be able to know which of my employees have been vaccinated, thereby who needs to quarantine in the event of exposure. Treat it like any other confidential health information. So it has to be treated like your ADA medical information, separate file, locked away. But that's the basics of the vaccine. Really comes back to you as an employer and what you want to do with it. Wanted to mention a little bit about the,
Sorry.
Hannah, was there something?
Yeah, sorry, there was a question. Just about the vaccines. Somebody's just very curious, as the vaccines are not approved by the FDA, how are the employers allowed to mandate the vaccines? Just some clarification there.
How the employers are allowed to, I mean, is really the EEOC has come out and said that the employers can. You know, there is that question of, you know, well, we're in the middle of this, you know, and there's still some questions as to what potential side effects are with the vaccine and things of that nature. But as of now, I'm just the messenger on this point. Is you can mandate it if you choose to do so. But you know, we're going to continue to see, I think, guidance from the CDC on this. There is some question, I think, and Trent, maybe you have any thoughts on this, as to employer liability if they mandate the vaccine.
Yeah, I mean, the one question is posed: if you do mandate the vaccine, an employee would get some kind of reaction or some sort of medical side effects from it. Is it a workers' comp issue? Which is an interesting question, and the answer is probably yes. So if you mandate the vaccine and side effects come from it, the employee would have a pretty strong argument that their vaccination was furthering the interests of the employer and was part of their work duties. And there's some case law that would back that up. So probably there would be a workers' comp, or could be a workers' comp claim from side effects from a mandated vaccine.
Wanted to just talk briefly about returning employees back to work and also remote workforce. And really, when we're thinking about, you know, continuing employees, with a remote workforce, again, be aware that the DOL is probably going to be doing more audits now. So with your salaried employees, you know, they are paid at the same salary they were when they were working in the office. Avoid fluctuations in salary, because if you fluctuate the salary, you're going to lose the salary exemption. So, you know, if you're seeing fluctuations in work, you're going to, need to keep that salaried employee at the same salary consistently. So if you move them down, they need to stay down. You can't just have them jumping around, because that's going to look like an hourly employee. You get a DOL audit and they're going to tag that employee as not being exempt, and they're going to treat them as an hourly employee, and you may be paying a lot of overtime for that employee, depending on how much time they've worked. Hourly employees, they are paid for all time worked, regardless of, whether you've scheduled it, whether you've approved it. If they've worked the time, they get paid. They need to be keeping careful records of the time that they've worked. So make sure they're submitting those time cards, those time records in. Make sure that you're paying them for the time that they're spending checking their emails, preparing for the meeting, not just going to the meeting, but the time spent preparing for the meeting is going to be compensable time. So those are things, because you can't see them, you need to be checking in with them and make sure, because if they were to report during an audit, well, I generally spent, an hour each night checking my email, but I wasn't paid for it. If you didn't know that, you're still going to get tagged for that. So you need to be aware of that. And so checking in with your employees. Best practice is to put something in writing, reiterate that back to your employees again, to say, hey, look, you need to be recording your hours. A reminder serves you well, serves your employees well. We're going to be bringing employees back into the office. I'm back in the office today, and it feels really nice to be back in the office and see people. There's going to be some challenges in bringing people back to the office, because people have gotten used to working from home. And some people are going to fight you on this. Now, the thing is it's primarily your discretion as the employer. You want everybody to come back to work. It doesn't matter that it worked 100% fine with people working remotely. If you want them back in the office, that's your prerogative. However, one of the things you're going to have to keep in mind is, if an employee claims, or let's not just say claims, if an employee has a disability and requests an accommodation to work from home, if they've been working from home for the last year, it's going to be pretty hard to say that's a an undue burden on the employer. They've been doing this. So this is an opportunity, I think, for employers to really look at their job descriptions. And if working from the office, working from the work site is essential to the job, you need to include that in your job description now. Because if it's not in the job description and they have been working remotely, if they request the accommodation, it's going to be very difficult to argue that they need to be in the office and that you cannot provide the accommodation of working from home. It's still going to be hard to make that, that argument, even though it's in the job description. But if you believe it to be an essential function of the job, make sure you're putting it in the job description. Flexibility, of course, is going to be important. We've been working from home. We've been flexible. We've adopted and adapted to things. When you make rules and you put a red line there, it is difficult for folks. And so being flexible a little bit, maybe it's bringing people back on a couple of days a week. Maybe it is looking at, are we going to have a flexible work week where people can work from home 2 days a week? Those are considerations for you as the employer. And really that's about you and managing your workforce. You're going to also need to think about managing your employees and their interactions with each other, because folks have been working remotely and they've been working in their own environments, and you're bringing everybody back together. And you should be prepared for some conflicts. And, as I would say with everything is, if those conflicts arise, is address them, document it, make sure that you're, addressing it though right away so that it doesn't come to a head later. And being aware that, that may be a normal growing pain of bringing people back into the office. And again, you are going to have folks who are going to request accommodations due to the ADA because they have a disability. And you're going to have to really look at that and say, are we bringing them back into work, or are we going to allow that person to work from home? And again, that's going to go to, is that an undue hardship on the employer? What are the essential functions of the job? But this is just going to be, a time, I think, period where you're going to have to be flexible, create uniform policies, be aware, be tuned into your employees and their needs, be tuned into any conflicts that you're seeing. And hopefully, we can get back to a normal working life that we all like. For me, I like being in the office. I like being around people. If you've been working remotely and it works for you and it works for your employees, and then maybe that's where you're going to go. We'll see. We're going to open it up for a couple questions here. Recognizing people's schedule here. If you need to tune out, that's okay. I do want to thank everybody for joining us today, and special thanks to Trent. Thanks to Hannah for just helping to navigate this, and thanks for Ian for joining us as well. So we'll open it up for any additional questions at this time.
Okay, so there is just a question regarding COBRA. They just want a little further clarification that if an employee is terminated for poor performance, or it was a position cut not related to COVID, they want clarification that still does or does not qualify for the free COBRA.
That does qualify for the free COBRA. Now, again, just to be clear, we're getting the DOL notice in a couple of days here on the 10th. That's going to provide additional clarity. My understanding is it's simply involuntary termination. So, whether that's poor performance, whether that is a position that's being eliminated, not due to COBRA, that employee should be eligible for the COBRA subsidy.
And somebody is wondering if an employee refuses to answer when they're questioned if they were vaccinated, what are the employer's rights?
At the end of the day, you can say, look, either you're telling me you're vaccinated or you're going to get terminated. hope that doesn't come to that. But, it is you're directing the employee to give me information. And if the employee is refusing to do so, it is the employer's prerogative to say, look, that's insubordination. And I'm telling you now, you either do it or you are going to be terminated. I would hope that there's other ways to address that. And maybe the employee's concerned about privacy. It may be that the employee is concerned about being, shamed because they didn't get the vaccine or because they did get the vaccine. And providing some assurances to the employee that, look, really what we need to know here is this because of our ability to know who needs to quarantine in the event of exposure. But at the end of the day, you can direct it.
We had another question regarding COBRA, but on more of the administrative side of it. If your company does in-house payroll, do you have any guidance that you can provide regarding getting the credit for COBRA, how they may go about claiming that?
So if you have not dealt with the FFCRA leave in the past, and so this is your first time having to go through this, and I'm a little rusty on this, but my understanding, my recollection is you have your employee FICA portion that the employer contributes. So the employer is paying the FICA contribution to the IRS. What happens with that is the employer withholds, doesn't pay that to the IRS, that FICA portion, and they withhold that amount through any of the employees, not just that specific employee, but all payroll, so that they pay, so that they get reimbursed for paying the COBRA payment.
And
I hope that
should be
gives you a little clarity. Ian, what was that?
it should be a relatively simple tax form to fill out. And we've been dealing with this from the FCRA tax credit reimbursements for almost a year now. So, if you're doing it internally, we should have an update out on the 10th when the new information comes out, and we'll have a link to that form. Or you can ask, any accountant should be well versed in the reimbursement side, the technical aspects of that.
The next question is, are employers required to offer the 12-week EFMLA if they offer the first 2 weeks?
I would think that's an all or nothing offer, both from just a fairness and spirit of the law standpoint, and also from a discrimination standpoint. I think it would get awful tricky offering certain portions of the leave to certain people or not to others. And then also, I think it would be hard to argue that you offer some part of some leave, but not all of it. And especially since all of the qualifying reasons apply to both types of leave now, it would seem that if you have a qualifying reason and the employer is willing to offer leave, that you should get all the leave. So.
Yeah, I think it is a all or nothing at this point. And so if you're going to offer the 2 weeks, you should expect to be offering the additional 12 weeks as well.
And the next question is about vaccinations. They would like clarification that Pennsylvania does have a religious exemption. And also there's a question if PA has a philosophical exemption.
No, I mean, there's a religious exemption. No, there's not a philosophical exemption. So the only exemptions, and again, this is not, to say that you can choose not to get vaccinated. Pennsylvania is not requiring, this is not a Pennsylvania requirement. This is an employer requirement. So if the employer chooses to require it, there are 2 reasons why the employee can choose not to get vaccinated and be exempt from that requirement. One being a bona fide religious belief. So you have to demonstrate that, in fact, this isn't just something I made up. This is something I actually believe. This is maybe something that my church, my foundational principles of my belief system is that I don't get vaccinated. Or there's a doctor's note saying that the employee cannot get the vaccine.
It's pretty much categorical at this point that a reason for not taking the vaccine due to efficacy misgivings about its approval or its development are not legitimate reasons under either of the exceptions, the religious belief or disability exception. So employers can be pretty confident in writing those off as not valid.
That is all the questions I have now. So I think we're all caught up.
Great. Thanks again. Get outside, enjoy the beautiful day. We'll see you guys later.
Bye, everyone. Thank you.